Do you have any idea why your elderly parents would need a trust plan if you are providing for them, or if they are living in senior living or any other home, or even in their own home? Well, for the same reason that you do, especially for that. What an estate plan does is it's a collection of documents that advocate for you while you are alive, and additional documents that transfer your estate, which is your assets, your inheritance, everything you own when you pass away. And more often than not, you will need your healthcare directive or your financial power of attorney before your will or your trust kicks in, because we're all living a little longer. Some of us are living till we're 90 years old, and you may need somebody. You may break an arm or have a slip and fall, break your hip, and you need somebody to help you with your finances. You need someone to help you make your doctor's appointments. So those are some of the documents that are part of your estate plan that you put in place that protects you while you are alive, so that if you are unable to enunciate what you need from the doctor or what you want from the doctor, you appoint an agent in writing who can do this for you. Now, often than not, adult children are allowed and able to do this for their parents because they have gotten to know, the doctors have gotten to know the adult children as the parents age, because at some point the adult children start going to the doctor with their parents. But if there's a situation where you have never gone to the doctor with your parents, I've never gone to the doctor with any of my parents, and then suddenly your parent is catatonic, they're in a coma and they can't speak, you can't just walk into the doctor's office and ask for information and ask to see their medical records and speak on your parents' behalf. If you do not have the estate planning documents in place, you need what's called a healthcare directive. And if you don't have that in place, they're not going to give you any information. If you don't have a written release from your elderly parent to have access to the medical records, they're not going to give you any information. So you should have these documents in place for your elderly parent, because if you don't, and your elderly parent gets to the point where they need help, you will have to go to court to apply for guardianship and conservatorship. And it's not fun, because even for the parents, the elderly parents that have dementia or touch of dementia, or way past, like, stage 15 of dementia, which is technically stage 4, they fully understand that you are trying to take their rights away, and they have to be personally served by a sheriff, and they have to be told what the paperwork is for, and they will fight you. And so if you don't have the emotional strength to stand up to your parent who will call you names and insult you because they don't really recognize that you are their child, but they do recognize that you are trying to take control over them, and they'll lose the right to contract, to marry, to purchase anything, etc. It's a very emotional process. I've had a client who resigned as the conservator of her father once she was appointed, because she couldn't handle the way he spoke to her. And he didn't mean it. He didn't even understand this was his child. So you don't want to have to go through that process. And so to avoid that, take your parents to an attorney now while they are of sound mind, and don't be angry when they do not allow you in the room. It is for your protection and your parents. I speak to adult children on behalf of their parents on a regular basis as part of the consultation, but I make it very clear to them that once I meet with their elderly parents, and their elderly parents engage a retainer agreement with me, I can no longer speak to their adult child. Now, if that parent turns around and gives their documents to the child, that's their business. That has nothing to do with me, but it's for everybody's protection, because the number one way that a person who objects can have your will or even your trust thrown out is by arguing that there was someone else in the room with you when you had it done, and that there's no way you would have created this document like this. Such and such must have influenced them. And regardless of whether or not it's true, if you are in the room, that's all it takes. That's all it takes for the court to throw that out. So that's why I throw you out of the room.